Hi, and thanks for joining the Talking Animals Law and Philosophy series. My name is Raphael Fazil, and I am the co-director of the Cambridge Centre for Animal Rights Law. Some of you may be joining the Talking Animals series for the first time, and I'm just going to say a few words how the Talking Animals series works. We will start with a presentation by our speaker that will last somewhere between 30 and 45 minutes. This part of the event will be recorded, and you can watch the recording later on our website or share it with friends. We will then move to a discussion that won't be recorded, and everyone is warmly invited to join in the discussion. Perhaps you'll have questions for our speaker, or you may have some comments that you'd like to make. If you would like to participate, please use the raise hand function. I see someone's already raised their hand, so they're very keen to participate. They will have to wait until the discussion, though, I'm afraid. But you can either do that or also pop your question or comment in the chat if that's a bit easier for you. The event as such will end at 6:30 p.m. UK time, so in about 1.5 hours. Until the discussion, I will have everyone's microphones muted, except our speakers, of course. Okay, I think that's all as far as housekeeping, and it is now my great pleasure to introduce our speaker today, and that's Professor Sergio Dellavalle. Sergio Dellavalle is Professor of Public Law and State Theory at the University of Turin, and he's also a senior research affiliate at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, Germany. And perhaps most importantly for us, he is also currently a visiting fellow at the Cambridge Centre for Animal Rights Law. Professor Dellavalle has held visiting position at numerous institutions, including Tel Aviv University, the Lauterpacht Centre for International Law here at Cambridge, Rutgers University, and the National University of Singapore. He has extensively published in the fields of political and legal philosophy, as well as on international and constitutional theory. Amongst his most recent publications is the book Paradigms of Social Order, which was published with Palgrave Macmillan in 2021. Presently, he is working on a book entitled A Republic of Fellow Sufferers, How to Grant Rights to Nature, which is forthcoming with Palgrave Macmillan. In this book, Professor Dellavalle explores the different strategies that have been developed to justify the attribution of rights to non-human natural entities. In his presentation today, he will tell us more about his research on this book, which he is currently conducting here at our center. So it is now my great pleasure to hand over to Professor Dellavalle.
Thank you, Raphael. First of all, I would like to thank the Cambridge Centre for Animal Rights Law for giving me the opportunity to discuss with you the outline of the book I'm now working on. This is going to be essentially a philosophical research and therefore a philosophical book. For that reason, I believe that my task should not consist in presenting arguments on how rights could be granted to non-human animals, but on why they should be granted to them. At the same time, I will also raise the related question on which non-human animals should be granted rights. Before I move on to the core of the topic, let me start by laying down three fundamental assumptions that lie at the basis of my inquiry. The first regards the definition of rights and maintains that rights are justifiable claims attributed to some entities in order to protect goods that are socially considered worth being safeguarded. The second assumption states that entities who possess those goods have moral relevance. The third assumption, finally, contends that having moral relevance constitutes the ontological and axiological foundation for some entities to possess legal relevance. In other words, legal rights have to be based on moral rights. Therefore, my attempt necessarily focuses on the determination on which goods deserve to be protected. The answer to this question will also clarify which entities are to be granted moral rights and thus legal rights too. Generally, we always thought that the goods that deserve being protected are those belonging to human society, such as freedom, justice, fairness, and so on. And most constitutions of the liberal and democratic world are founded on this belief. However, if we want to show that non-human natural entities also have rights, then we have to demonstrate that there are goods to be safeguarded which do not belong only to humans, so that consequently also non-human natural entities should be recognized as possessing moral relevance. Basically, there are 5 strategies that have been developed to support the recognition of moral relevance and legal rights to non-human natural entities. One is, at least at first sight, a non-starter. 3 of them are well established, and the last one is my proposal. Starting from these premises, my presentation is essentially made up of 2 parts. The first one will give a short account of each one of those strategies with their pros and cons, while the second one will focus on the 5th strategy, namely the one which is at the core of my inquiry. The first strategy, which I call the non-starter, resorts to the notion of dignity. The first and foremost downside of this strategy consists in the ambiguity of the notion itself. For the sake of our conversation, let us assume that dignity is the principle that imbues all rights, helping us to implement and interpret them. However, this assumption does not say much about the possible content of this principle. Only we clarify the content of dignity, that means what makes an entity dignified, we will know which beings possess dignity and which do not. Therefore, is dignity based on the sheer fact of being part of creation, or on being a sentient creature, or on finally being a rational entity? Evidently, the attempt to clarify what dignity is meant to be only demonstrates that this notion is essentially a conceptual space to be filled with some more consistent content. Such a conclusion necessarily refers us to the other 4 strategies, hoping that they make more robust statements about the goods to be safeguarded. Before we move on, nonetheless, a remark should be made. In fact, most authors who make use of the notion of dignity in the debate implicitly or explicitly link the possession of this quality to the capacity to act rationally. By doing so, obviously, they exclude all non-human animals from possessing not only dignity, but mostly also any kind of rights. This is essentially the reason why I call this strategy grounded on dignity a non-starter. Yet, should this negative judgment as regards the possibility of using the notion of dignity with deference to non-human natural entities be considered final? In other words, is dignity really useless or even harmful for the attempt to extend moral and legal consideration beyond the boundaries of the human community? Well, not necessarily. Once again, it depends on how we define dignity. In fact, we could recover the notion and make it useful for our purpose, but only on the condition of understanding it in a way which is quite unusual. I will get back to this aspect near the end of my presentation. For the time being, in search of a more convincing solution, let us address the second strategy, which is centered on a holistic understanding of nature. This strategy has shaped a great part of the environmentalist discourse from its very beginning until the present day. However, the notion of holism can be understood in two different ways. So to say, in a minor or in a major key. According to the former, holism simply describes the overcoming of a short-sighted anthropocentric view, so that humans are ultimately willing to expand the criteria for moral relevance that they apply to themselves to all non-human creatures who fulfill them as well. This view, which is grounded in the principle of equal consideration, maintains the central importance of humans in creating the moral and legal community, but extends the horizon of this community according to a change of its foundation and to general considerations of justice. On the contrary, holism in a major key utterly rejects anthropocentrism by directly challenging the axiological priority usually given to humans over nature. According to this approach, nature is conceived of as a whole whose components, including humans, are all characterized by moral relevance for the simple reason of being part of the natural web. Holism in its major key starts with the assumption that all human and non-human elements of the natural world are parts of an organic whole in which everything has an essential function to fulfill and therefore deserves respect. Now, let us shortly concentrate on the up and down sides of the holistic view. That means on what we can really want, but also on what can possibly go lost by taking on this approach. According to the holistic understanding of nature, as already mentioned above, every element of the web of nature has moral relevance and possibly also holds rights, for the simple reason of being part of this natural web. Therefore, the holistic approach is well equipped to serve as a conceptual foundation for a better protection of ecosystems and biotopes, and therefore for supporting the inevitable environmentalist turn. On the other hand, however, it should also be taken into account that if we are serious about the holistic assumption according to which the highest moral relevance is to be given to nature as a whole, little room is left for the relevance of humans or of sentient beings in general. Are we really willing to make this step that means to put the law of humanity beneath the laws of nature? And what is of the suffering of the living creatures in this case, or of the fact that morals are ultimately a product of human endeavor? The third strategy narrows down the number of natural entities that are considered morally relevant and possible holders of rights prima facie. Here. As the name of this approach, namely biocentrism, already reveals, it is not all components of the web of nature, including biotopes and ecosystems, that deserve moral and legal consideration, but only those among them that belong to the living world. Two main critiques can be raised against the biocentric term. The first is largely in the same vein of the reservations already expressed with reference to holism. Indeed, if all living creatures have inherent moral relevance, and this relevance is grounded on the sheer fact of being a component of the community of life, it becomes difficult to locate the intuitively undeniable specific quality of those creatures who are capable of suffering and feeling pain. The second criticism refers to the moral intuition that some living beings who represent a danger for health and safety of humans and other sentient animals, such as pathogens microbes, and some parasites are rightly excluded from moral and legal protection. However, if this intuition is argumentatively tenable, then the whole construction of post-anthropocentrism begins to stagger. As a result, it is to be taken into account that maybe a less radical position, aiming at reinterpreting and expanding anthropocentrism and not at overthrowing it, might turn out to be not only more feasible, but also more conceptually convincing. The barycenter dramatically shifts with the fourth strategy, according to which the central argument for attributing moral relevance and legal rights to known human natural entities does not derive from their belonging to an encompassing web of environmental interconnections or from their being part of the living world, but from a far more discriminating and exclusive criteria, namely from having arguable and at least germinally conscious interests. In doing so, the interest-based approach marks a relevant change of perspective. Indeed, holism and biocentrism openly pled for a relocation of the reference point of the moral and legal argument from human to the environment. If humans are nonetheless granted moral relevance, this happens only because they are part of their natural environment. On the contrary, the interest-based theories consistently claim that moral relevance is not an objective condition rooted in the world, but the product of the human mind, which has been first and foremost created to be applied to human beings. However, if we deem it rational to assert that we possess moral relevance as human beings because we have a certain kind of justifiable interest, and then it turns out that those same interests are shared by at least some non-human animals, according to the principle of equal consideration, we are morally bound to accord moral relevance to them as well. This is the reason why we can say that the interest-based approach does not reverse, but rather corrects and expands the anthropocentric view of moral discourse. Here, in fact, the community of human beings is still regarded as the starting moment and the centerpiece of any moral argument, which does not imply that the consequences of those moral arguments are to remain limited to those for whom they were created. The interest-based approach comprises two main different theories that differ from one another on the basis of interest that each of them respectively regards as essential and thus worthy of being protected by moral and legal norms. Following the first theory, which grows out of the main assumption of utilitarian philosophy, the main interest consists in avoiding pain and maximizing happiness. Since we have well-justified reason to maintain that some non-human animals are capable of feeling pain, they necessarily share that same interest with humans. The second theory identifies the fundamental interest in the development of some capabilities which are considered essential for the thriving of the creatures endowed with them. Inasmuch as the unhindered deployment of those capabilities is key for the self-realization of some living beings, curbing their use is an act of moral violence. And because this condition, once again, brings together humans and some non-human animals, the principle of equal consideration commands to safeguard the latter and their drive to self-realization too. In spite of their difference, the two variants of the interest-based approach have a fundamental element in common. Indeed, while the first among them emphasizes the dimension of pain as the epiphenomenon of the value that should be protected, namely physical integrity, the second focuses on the distress that is generated by the impossibility to realize one's own potentiality, thus highlighting what can be defined as suffering. As a matter of fact, feeling pain and suffering are to some extent distinct in their expression and are displayed by different groups of living beings. Nonetheless, they share and both rely on the condition of being sentient. Therefore, sentience becomes the essential factor on which all forms of interest-based theories for the attribution of moral relevance and legal rights to non-human natural entities are grounded. As a result of its premises, the interest-based approach does not justify the attribution of moral relevance or legal rights prima facie to ecosystems or biotopes. Nor does it grant them to all living beings, but only to those among them who are endowed with sentience. This does not imply that the other components of the natural world, from landscapes, ecosystems, and biotopes to non-sentient living creatures, do not deserve protection. On the contrary, they have to be safeguarded, but only indirectly. That means insofar as they are essential for the quality of life of humans and sentient non-human animals. No doubt can be seriously raised about the intellectual consistency of the interest-based approach. We generally took the debate on the topic to a higher level. However, it is not free from some weaknesses. In particular, it gives up on the idea that moral and legal rights should be the outcome of a process of mutual recognition in favor of a rather top-down approach. Indeed, following the viewpoint of the supporters of the interest-based approach, rights are recognized on the ground of the knowledge developed by the most competent experts in the field, who are supposed to bring the best arguments for the acknowledgement of rights to some entities and not to others. The social and discursive processes that necessarily go hand in hand with the broad acceptance of rights and obligations are therefore put in the background. And so are the political consequences too that might be generated by this relevant turn in the theory of the use of practical reason. At first sight, the fifth strategy, namely the agency-based approach, seems by far the least suited for the purpose at the center of my inquiry. Following this theory, rights are entitlements considered necessary in order to safeguard free and rational agency. It goes without saying that such an understanding is hard to apply to beings who, though sentient, are neither free nor rational in the way in which we use these concepts with reference to human beings. Among the different variants of the agency-based theory of rights, there is one which is particularly important for the question addressed in my research. Namely, the interpretation according to which free and rational agency is not only the good to be preserved, but also the starting point of the whole process that ultimately leads to the recognition of rights. In other words, rights and corresponding obligations are here regarded as generated through the mutual recognition of fundamental entitlements by the members of the moral and legal community. Thereby, the same members acknowledge to one another the necessary prerequisites to interact with one another in a way that allows the self-realization of each one of them. This variant, which we can define as the enhanced agency-based theory, or more precisely, as the recognition-based theory, has the advantage of disconnecting the recognition of fundamental rights from the technocratic presupposition of a privileged observer, while inherently linking it to the deliberative processes of democratic societies. It is not surprising under these circumstances that the recognition-based theory of rights has played a significant and decisive role in the conceptual underpinning of the transition from the autocratic to the democratic form of state. However, no matter whether we ground rights on the guarantee of free and rational agency or on the mutual recognition within the community of the free and equal, non-human natural entities seem inevitably to be excluded from the attribution of rights. Yet, on closer inspection, this conclusion ends up being far less compelling than we may assume at first. Indeed, there is a way to include some non-human natural entities into the community of the rights holders, even if only as moral passions, and admittedly at a somehow lower level than the members of the human species. This way relies on an idea that the recognition-based theory of rights already puts in place when it is applied to human rights holders, namely the argument for marginal cases. Indeed, some human beings who are not able of mutual recognition because they are, for instance, too young or mentally disabled, are nonetheless regarded as members of the community of rights holders simply on the basis of the consideration that the quality that constitutes the community and also represents the good to be preserved, namely the capacity of acting rationally, has to be regarded as essential to their potential identity. To include some non-human natural entities into the community of rights holders, however, we have to go much further on the way to a redefinition of the fundament of the moral and legal community. Such a redefinition is grounded on something which amounts to no less than a change as regards the very basis that essentially characterizes the community of rights holders. According to its traditional understanding, this basis is identified, as already said above, in the capacity to act rationally, so that this same capacity is also seen as the good to be primarily safeguarded through the attribution of rights to those who can actually exercise them, as well as to those who could at least potentially do the same. Following my approach, on the contrary, the essential good to be preserved within the community of rights holders is physical integrity, so that its members, actual or as well as potential, acknowledge entitlements to one another on the basis of the recognition of a shared vulnerability and of the capacity to suffer and feel pain. This view is supported by an understanding of language that does not see in its development the result of the attempt to exchange rational arguments in order to achieve certain abstract goals, but as the linguistic interaction that, by expressing common vulnerability, strengthens the bonds of the community and prevents its members from suffering harm. Consequently, the community of the rights holders becomes a republic of fellow sufferers, a community that includes all natural entities that share the same condition of conscious vulnerability, that means all sentient beings. More specifically, the Republic of Fellow Sufferers should have a multi-layered structure with a kernel of human beings with their capacity of acting rationally and an expanded circle of moral passions who share with them the morally fundamental element of vulnerability. On the basis of the idea of the Republic of Fellow Sufferers, we can also reintroduce the notion of dignity as applied to non-human sentient beings. At this point, it should be said first that world religions offer solutions that in most cases attribute at least a kind of second-level dignity to natural entities. Some religious traditions, in particular Buddhism, Jainism, and to some extent also Hinduism, go even further and highlight human responsibility to restore nature and the community of destiny of all living beings. Therefore, the case for the recognition of the dignity of nature is not definitively lost, not even if we leave the field of belief and enter that of purely rational argumentation, precisely that kind of argumentation that seemed to disqualify dignity in general, or at least with reference to its application to the natural environment or to parts of it. Yet for the rational recognition of the dignity of nature to have a chance to succeed, two conditions have to be met. Firstly, dignity should be regarded as the moral value and legal principle that encompasses all the individual rights and guides their interpretation. In other words, individual rights are seen from the viewpoint of the moral value that constitutes the social content of the concept of dignity. Secondly, the value that identifies the moral and legal community in its social dimensions is the protection from harm. In this sense, not rationality is the distinct quality of the members of the moral and legal community, but vulnerability. Therefore, dignity rests on the capacity to mutually recognize our own frailty and to enact the norms that prevent the members of the community from avoidable suffering. Ultimately, dignity qualifies in a first step all members of the moral and legal community who are capable of mutually recognizing their common vulnerability. And in the second move, on the basis of the principle of equal consideration, all natural entities who share the same essential disposition to feel pain and to suffer in a conscious way. Now let us see how the idea of the fellow sufferers and the revised recognition-based theory address four very difficult questions, arguably the most uncomfortable challenges that any theoretical attempt to include non-human natural entities, or at least sentient beings, into the legal and moral and legal community has inevitably to meet. The first question. The first challenge concerns the question of whether we are allowed to kill sentient non-human animals, and if the answer is in the affirmative, under which circumstances we can do so. In search of a solution, let us make a mind game. Let us assume that any one of us is in a forest and starve. Nothing edible is to be found nearby, but it happens that we are equipped with a rifle. At first, we see from the distance a fellow human, but a certain moral intuition tells us that it would be wrong to kill and eat them. Therefore, we refrain from using our weapon. Shortly afterwards, we see a deer. I guess that many of us would say that our moral intuition now allows us, even with great sadness maybe, to shoot the animal and in order to survive. However, none of the three strategies from 2 to 4 presented before, namely the holistic, the biocentric, and the interest-based strategies, would justify our action. In fact, the holistic understanding of the world will give to the deer an analogous, but probably even a much higher value if compared to humans in maintaining a healthy homeostasis of the natural web. From the viewpoint of biocentrism, then, the deer is no less a living being than the human. And finally, the deer has a similar interest to live and to thrive as we have. I know that the supporters of the interest-based theory introduce a certain difference in weighing the interest of different living beings, but this distinction seems to be conceptually difficult to maintain. Should we therefore conclude that our moral intuition is simply wrong and no difference should be made between humans and other sentient beings? Well, not necessarily. In fact, the conceptual framework that lies behind the idea of a republic of fellow sufferers supports our moral intuition, though not without introducing a significant caveat. To be precise, the two-tier structure of the community of the rights holders, according to which we have a kernel of members based on mutual recognition, and more peripheral rights holders, included on the basis of the principle of equal consideration, allows us to maintain that in case of conflict, we are justified to treat them in a different way, namely to give priority to the former against the latter. However, this should only happen in the most extreme cases, namely when the survival of the essential well-being of the members of the most central level of the moral community, of its recognition-based kernel, are at stake in an existential way. Second question. The question about the conditions on which it should be allowed to kill sentient non-human animals following the approach of the revised recognition-based theory also reverberates on the second issue I wanted to shortly present, namely the use of non-human animals in scientific experiments, testing, and education. The theory I advocate indeed tends to justify a very cautious and limited display of this praxis. There is a direct and inevitable conflict between comparable rights of human and those of non-human animals, the first category of rights is to be granted priority. However, this principle can justifiably be applied only on the condition of a strict compliance with certain requirements. Firstly, insofar as experiments are trivial and useless, and there are many of them in our usual praxis, we are morally required to plainly stop carrying them out. Secondly, the goods at stake should be really comparable, which is not the case when the physical integrity of non-human animals is harmed for the testing of non-essential products or for the gathering of knowledge that has no direct impact on our well-being. Thirdly, the policy of the 3 R's, replacement, reduction, and refinement, should be implemented without hypocritical hesitations. In particular, alternative strategies should be developed at the fastest possible pace, whereas the fact that not enough resources have been invested in new solutions should not be regarded as a justifiable justification to keep on using the same old methods. The third question focuses on our possible obligation to intervene to avoid the suffering of sentient beings in the wild, including the suffering that inevitably results from predation. If we embrace the understanding of sentientism advocated by most utilitarians and supporters of the capability approach, the answer is unequivocal. We should, indeed, since our obligation consists in avoiding pain and suffering without contextual limitation. This includes not only helping wild animals, not belonging to endangered species, by the way, at risk of starvation or impacted by natural phenomena, but also avoiding the introduction of apex predators, favoring the extinction in the wild, as well as implementing the genetic modification so that carnivores can live on vegetables. Once again, this answer seems to be somehow counterintuitive, and in fact, some of these solutions and proposals raise significant skepticism amongst biologists. Again, let us explore which arguments might support skepticism as regards our intervention to prevent suffering in the wild. The most significant amongst them is arguably the so-called argument from ignorance, according to which, given the complexity of ecosystems and our limited knowledge, we should refrain from intervention that inevitably impact on interactions whose internal mechanism and wide influence we do not understand. Obviously, the most intuitive objections to this approach contends that if the problem is the lack of knowledge, we could at least intervene where our comprehension of the ecological context is good enough, trying at the same time to expand our awareness of biotic interactions so that the field for our practical engagement can grow as well. In fact, this counter-argument is only destined to fail if a strict principle of caution is applied, so that it is assumed that the imbalance between our knowledge and the complexity of the world, at least in some field with ecology belonging to them, can never be convincingly bridged. Considering how far-reaching and epistemologically contestable this assumption is, the focus necessarily switches to the second argument against the moralization of nature, which is also the position taken by the revised recognition-based theory and by the vision of a republic of fellow sufferers. We can define this as the laissez-faire argument, which maintains that we have no obligations toward non-human animals with whom we are not entangled. In fact, the Republic of Fellow Sufferers does not aspire to become a cosmopolis of all sentient beings. That means to include all living beings capable of feeling pain and suffering. It is intrinsically, and it is destined to remain, a creation of the human will and of the human tendency to morally justify actions. Its range reaches up to where human society impacts, but no farther. Therefore, the acting members of the Republic of Fellow Sufferers bear responsibility for all kinds of suffering in the natural world that might have been caused by human activities. Hardships of sentient non-human animals because of human-made loss of natural habitats, for instance, require human intervention. Actual involvement is also due if natural habitats are in danger of being destroyed and can only be salvaged by human hand. Furthermore, there may be good reasons for humans to intervene when the suffering happens in places where the Republic of Fellow Sufferers and the community of wild animals overlap. An example of this situation is the feeding of wild animals at the edge of human settlements. Human action is also justified when the impact of natural conditions takes the dimension of a huge catastrophe. Nevertheless, apart from these cases, we can and should do nothing to ease the day-to-day suffering in the natural world and to stop the intrinsic cruelty that is the other side of the beauty of nature. Simply, the realm of wild nature is not part of the Republic of the Fellow Sufferers and follows a different kind of laws, the laws of nature and not the laws of morals. The only suggestion that could be made with reference to the natural world is that we should stop uploading disturbing footages of animal-to-animal cruelty on social media. Maybe we cannot overcome the suffering, but we should at least show some compassion. The fact that human intervention might be justified to protect natural habitats recalls the question of the conflict between environmentalism and animal rights. While the Republic of Fellow Sufferers recognizes animal rights, it is also committed to preserve natural biotopes. To resolve the problem, the revised recognition-based theory can benefit from the suggestion to address this from the point of view of the limitation that fundamental human rights may be subjected to in order to safeguard legitimate public goals. From this perspective, even the right to physical integrity of sentient non-human animals can be waived if the action threatens to destroy an essential common goal, like a non-replaceable natural habitat. This is analogous to the situation in which the right to life of human beings is counterbalanced and surpassed by the right to physical integrity of those fellow humans who are threatened by the actions of the trespassers. No doubt can be raised on the fact that invasive alien species pose a similar existential threat to the inhabitants of the habitats they are going to conquer. Put bluntly, this means that these animals can be justifiably killed. This intervention is morally acceptable, however, only if two conditions are met. Firstly, before we move on to the culling, every other non-cruel and feasible solution must have been taken into account. Secondly, the killing of the invasive species animals should happen by applying the criteria of the least possible suffering. Concluding, the project of a republic of fellow sufferers can probably be best described as a form of enlightened anthropocentrism, rather than as a radical rejection of the central role to be played by humans in the moral, legal, and political community. To some extent, the Republic of Fellow Sufferers can also be addressed as a kind of holistic anthropocentrism, inasmuch as it maintains the centrality of humans as the bulwark of the moral and legal community. At the same time, however, it overcomes the usual conceptual limitation of anthropocentrism by reshaping the boundaries of that community and by integrating a holistic vision in a minor key. Thank you very much.